Thank you, counsel. Justice Thomas, Justice Sotomayor, Justice Kagan.
Mr. Clement, you spoke in your opening about the apparent anomaly between putting the vertically integrated oil companies in federal court and having the oil-producing companies that don't have refining capacity, didn't have refining capacity in state court. And you said we oughtn't to worry about that. But putting aside for now the Solicitor General's alternative theory, which would treat them alike, I mean, why isn't that just a bizarre outcome when you consider that this entire suit is about the thing that both sets of those companies have in common, not about the thing that separates them?
So again, I'll grant you that there's like a surface anomaly, if you will, which is why my clients in the first instance are, the SG position is our position, our principal position in the Fifth Circuit until it's rejected in the Plaquemines 2 case. But what the Plaquemines 2 case says is, our problem is acting under, not really related to. And so, and even in the Plaquemines 2 opinion, it's like 4 pages long. It doesn't say much, but it does say maybe the refining companies are differently situated. And so, so I think the anomaly goes away if you think about this as principally acting under. It makes a big difference unless you accept my sort of modification based on the unique nature of these regulations. If you think the key problem is acting under, well, then it makes sense that the people who are in direct government contractual privity with the federal government get to remove, and those that are not don't get to remove.
And when acting under, are you saying that every federal contractor is acting under?
So what I would probably say is, like, in some theoretical way, if you're a government contractor, you could come in and say, I'm a government contractor, so check that acting under box, but it doesn't do you any good unless what you did under the government contract is related to the thing you're being sued for. So if Chevron is, got a refining contract and they get sued for their geothermal operations, or they get sued for operating a corporation-owned filling station, like, related to is going to be absolutely impossible, and so you check one box, but you wouldn't get anywhere. I mean, essentially everybody gets to check the I'm a person box, but that doesn't move the needle. So I wouldn't worry too much about saying, well, government contractors get to check the acting under box, because they still have to get related to, and they still have to show a colorable federal.
And then unrelated to, which is pretty broad. So the fact that you still have related to, I'm not sure how much that work does in terms of limiting this. But, to take a hypothetical where it's not wartime and there's plenty of crude to go around, and the government doesn't have a particular interest in what happens at the production level as opposed to what happens at the refining level. But it's still, of course, true that the crude oil is the single component of the aviation gas. Is that enough?
Sure, I think that is definitely enough.
So all the rest is atmospherics. The fact that the government was super concerned about this and, was really looking at the production activities too, in order to ensure that the refiners got the crude that they needed, even if that wasn't the case, just the fact that the crude was the component product is enough.
It would be enough for the related to box. It's a lot more than atmospherics. It's part and parcel of why I don't fear the possibility of being remanded for the colorable federal defense prong here. And if it were just ordinary, non-wartime, kind of generic stuff, I'm not sure what the colorable federal defense would be. But for purposes of the related to, I honestly think if you take the wartime context out of this, and the government contracts with Chevron Refining Company, it's probably guessing that almost all of the crude is going to be produced by Chevron in the field, because they vertically integrated for a reason. It's efficient for them to operate kind of as an internal corporate entity. So in some respects, the wartime context had a little bit of the anomaly that we didn't refine as much of our own crude as we otherwise would have, but it also provides all this other direction and control that I think make the colorable federal defense an easy piece. The other thing it does, which is more than atmospherics, is I think it provides part of the answer to why contractual direction can't be the test. Because part of the reason the contract didn't have to specify anything more about production is because that's being regulated to a fare thee well by the Petroleum Administration for war.